may I just start by saying Igama lamakhosikazi malibongwe. We are gathered here today to celebrate June 16th, which is categorized as Youth Day in South Africa. Now, if I may just start by this quote from Nelson Mandela, which says that education is the most powerful weapon which you can use to change the world. Gathered here today, we're here to commemorate the events that took place in Soweto on this day in 1976, otherwise known as the Soweto Youth Uprising. The Soweto Uprising was a series of demonstrations and protests that led by Black school children in South Africa under apartheid back then, that began in the morning of 1696, wherein students from the various schools back then took to the streets in response of the introduction to the medium of instruction at the time in their schools, and those the medium of instruction was Afrikaans. And those protests were then met with police brutality, and there were a loss of life and casualties on that day. Now, 1976 was a major turning point in South Africa's history, and that day marked the end of submissiveness on the part of the Black population of South Africa. The South African youth took center stage on that day, and they remained to the forefront of South Africa from that day forward. With that said, ladies and gentlemen, I think it is quite evident that, especially in our country, when the youth do take charge, meaningful change becomes the result. With that, that was my opening introductions. My name is Sidi Shokali, and I'm going to be the program director for the day. Without any further ado, ladies and gentlemen, may I just ask our president to come through and give us the presidential address and the proper welcoming of the guests.
President, I
Madam
think
President, you're muted.
Sorry. Good morning, erudite panelists and our esteemed guests. Before you is Ndlovu Ziyabokwa, who is the president for the South African Black Women in Law Organization. With me, I am with my ex-core team members, my deputy president, Nombulelo Gumede, and Secretary General Lindelwa Zulu. Allow me to open up today's event with Ray Goforth's quote, and I quote, "There are two types of people who will tell you that you cannot make a difference in this world. Those who are afraid to try and those who are afraid that you will succeed." Close quote. On behalf of South African Black Women in Law, we are delighted to invite you to a virtual meeting under the topic, Actualising Section 29, the right to education in legal practice. This event aims to bring our esteemed legal professionals like yourself to exchange ideas and discuss emerging trends and foster collaboration within the legal community. The month of June, as we know, is upon us, and in remembrance of the fallen youth of 1976, the whole of South Africa will be commemorating the Soweto Youth Uprising, which took place on the 16th of June, 1976. On this day, Black students from Soweto took to the streets to protest against Afrikaans and English being made the only medium of instruction and learning throughout the country. The students of 1976 were fighting for what has now become one of the most important rights enshrined in the Constitution of the Republic of South Africa, 1996. Section 29 of the Bill of Rights. Section 29, subsection 2 recognizes that everyone has a right to receive education in the official language or languages of their choice in public educational institutions, where that education is reasonably and practicable. As mentioned above, the implementation of Section 29 forces an array of hurdles. However, the South African court, through their judgments, continue to protect the right to education. specifically Section 29, subsection 2, and thus live up to their duty to act as the guardian of the Constitution. One of these judgments is the case we will be dealing with today. SABWiL is an international conscious movement that celebrates South Africa, Blacks, women, and law. We are founded upon dignity, equality, and freedom infused in the philosophies of Ubuntu and Zenzele. Our ethos resonates with the values and beliefs that fueled the youth of 1976 and propelled it to fight for a better South Africa. The actions of Mbuyisi Makuba, an 18-year-old pupil who carried Hector Peterson, is a clear personification of the philosophy of Ubuntu. His act of bravery proved that indeed, umtu ngumtu ngabantu. Moving to the next agenda of the day, I would like to introduce our guest speakers, the panelists. I'll first start with our first speaker, Advocate K. Mchweu, is the member of the Church Square Association of Advocates. His introduction goes as follows. I am a solution-orientated practicing advocate with experience in handling civil, commercial, and intellectual property and labor law issues. I have well-crafted legal drafting and reviewing policy skills, as well as potent litigating skills. I am in the profession of an LLB degree from the South. I am in possession of an LLB degree from the University of South Africa, UNISA, in short, and I am a member of the Church Square Association of Advocates. Student leaderships that he took role in. Former marketing officer of UNISA Law Student Association, Tshwane region in 2016 up until 2017. Former deputy secretary of the Black Lawyers Association student chapter, UNISA Tshwane branch 2016 to 2017. Former chairperson of the BLA SC UNISA Tshwane branch 2016 to 2017. And former national spokesperson of BLA SC in 2018 to 2019. His professional experience beyond practicing as an advocate, he is currently a legal advisory board member for the media company called Metric Productions. He has previously been in an in-house legal counsel of Lisiba Mabitsela Studio Pty Ltd. He's a director at a legal consultancy firm called Azania Legal Advisory and Consultancy, a postgraduate assistant at UNISA's Mercantile Law Department, as well as a legal intern at the intellectual property law firm by the name of Chaya Mashabela Attorneys Inc. One of the cases that he was involved in that has a reported judgment, it's notes on behalf of Malinga and others versus Road Accident Fund 2023, 3 SA 125. His mentorships is previously a student representative for UNISA at the BRICS Legal Forum Conference in 2018. Is a LLB student mentee to Acting Justice Margaret Victor in 2018 through the South African chapter, International Association of Women Judges Student Mentorship Program. He previously participated in SABWiL shadowing program as a student mentee in 2018. Moving on to our second panelist. That is no other than Advocate Zimasa Mashia. She did her LLB degree at the University of Fort Hare. She took a gap year for years to do ministry and was active in an organization that focused on a betterment of women and children. She did her articles at Smith Tabata. She served as a president of the Candidate Attorneys Association, got a call to the bar in 2020. Currently an active member of SABWiL and BLA. That's it from my side. I'd love to pass it back to our program director for the day. Thank you.
Thank you very much, Madam President, for the introduction of our speakers. I think let us proceed with hearing from our first speaker, being Advocate Koketso. Let's hear what his thoughts are in relation to the program for the day, being Section 29 of the Constitution.
Good morning, everyone. Thank you, Ms. Siabuka, for the introduction. It's very much appreciated, and I'm humbled that I was invited to speak to the young people today in relation to the topic at hand, being Section 29, subsection 2 of the Constitution. So thank you very much. I am Advocate K.M. True, as introduced by the program director as well as the president of SABWiL. So I greet you all in accordance to all protocols that may be observed. So yeah, when I was asked to talk on this particular topic, I found it quite interesting in relation to the provision itself to be discussed, particularly the specific case law in hand, being the Khalka-Kansea case. It did bring forward quite a polarizing discussion in relation to the language policy that we have here in South Africa in relation to the right to education. It is quite an interesting and polarizing issue to be discussed. Now, I'm not sure if everybody has read the judgment, but the Khalka-Kansea case had to do with the right to education, as far as to be taught in one's own language, as far as reasonably or practically possible. The provision itself paved the way for quite an in-depth discussion in which, from my understanding of the judgment, students of the University of sorry, just give me a moment. Students from the University of Stellenbosch took to the court, I believe at Western Cape High Court, in order to make an application in order to address what they believe to be a discrimination of their rights, particularly Afrikaans-speaking students, in which there was a development of the University of Stellenbosch's language policy. Now, there was a language policy that was previously in place in the year 2014, in which the University of Stellenbosch sought to change and amend this and update this policy due to the fees must fall strikes that occurred around 2015, and it chose to develop a new language policy in 2016, which the university believed was in line with Section 29, subsection 2 of the Constitution. Now, obviously the applicants, being Khalka-Kansea and I believe 6 or 7 other students, believed that their rights were being discriminated because of the language policy specifically spoke to not being able to be taught Afrikaans in real time, but instead receive translations, particularly in relation to their study material. Now, Justice Cameron gave a very interesting judgment in relation to this case as to how polarizing the discussion is around foreign policy. Now, obviously, the applicants in this case, they were of the strong opinion that what was being done was an infringement of their rights because of essentially the Constitution provides that the state is obliged to provide this opportunity to students to be taught in their home language, or in their preferred language, as far as reasonably or practically able to do so, and it did so, and so that's what they were relying on. Now, what was quite interesting is that this judgment, it spoke to specific two cases, in which this issue was already particularly discussed in, being the Armello case and the Afroforum case, both which were heard in the Constitutional Court, as well as this Halka Kanzia case that was also held in the Constitutional Court. Now, I'd just like to quote somewhat a paragraph from the Armello case. The full citation is Head of Department, Mpumalanga Department of Education, and another verse, School Armello and another. 2010, in brackets 3, BCLR 177 in brackets CC for the Constitutional Court, in which the following was stated in paragraph 52. The provision is made up of two distinct but mutually reinforcing parts. The first part places an obvious premium on receiving education in a public school in language of choice. That right, however, is intentionally modified because the choice is available only when it is reasonably practical. When it is reasonably practical to receive tuition in a language of one's choice, it will depend on all the relevant circumstances of each particular case. They would include the availability of and accessibility to public schools, the enrollment levels, the medium of instruction of the schools, its governing body has adopted the language of choices, learners and their parents make, and the curriculum options offered. In short, the reasonableness standard built into Section 29, subsection 2, paragraph A, imposes a context-sensitive understanding of each claim for education in language of choice. An important consideration will always be whether the state has taken reasonable and positive measures to make the right to basic education increasingly available and accessible to everyone in a language of choice. It must follow that when a learner already enjoys the benefit of being taught in an official language of choice, the state bears the negative duty not to take away or diminish the right without appropriate justification. Now, the reason why I quote from the Armello case is because of it would seem the debate around in the case, in this Halkia cancer case, was around this particular understanding, is that by virtue of the University of Stellenbosch amending their language policy and somewhat going from the Afrikaans language being taught in real time, and now from real time into rather documents that are translated, and even then it wouldn't be throughout all courses. It would be courses in terms of what the University of Stellenbosch says they can afford, or is what is feasible in terms of their budget. And so this is the contention therein lies. Now, obviously, we all know the history behind Afrikaans and its polarizing history in relation to apartheid itself, and hence what sparked the debate and the quite lengthy and debative judgment that was presented by Justice Cameron, and obviously agreed with by his fellow constitutional judges at the time, concurring to his judgment. So it is that. Now the truth of the matter is, Afrikaans is still a language that a lot of people still speak. It's still considered an indigenous language despite its polarizing history that comes with it, particularly the 1976 school children uprising, in which a lot of children at the time were on the streets striking that they don't want to be taught in Afrikaans. But here we find ourselves in a judgment from as recent as 2019, in which students, university students, were insisting that they be taught Afrikaans in real time. And so that's what essentially arises from this polarizing discussion, is that how that if we have to give Afrikaans speaking students real-time education, then we have to do the same, in which that's what the University of Stellenbosch was arguing in this case, that it's not feasible nor possible. In fact, Justice Cameron went as far as even discussing the percentage in terms of that region of the country, in terms of different speakers, in terms of people speaking English, Afrikaans, isiXhosa, and how that if we want to really follow through with the principles that the applicants were arguing for in this case, then we would have to apply to isiXhosa speaking students as well, and any other students that might come to the university itself. But then we need to do so within the means of what is practical and what is reasonable to do so. And so it was quite an interesting judgment that it gives. It's quite an interesting judgment and quite an interesting discussion that it sparks as to, now in 2023, what is the relevance of Afrikaans in terms of from a language point of view in education, whether it be from primary, high school, or tertiary education. Obviously through this case, and even through the AfriForum case that was also held in the Constitutional Court, it seems it is still a discussion that some people speak. It's still a language that a lot of people speak. Some white, obviously, some black people, some colored people. And so it is still a medium form of language that a lot of people speak. And so as polarizing as the history that it comes with, people still have to somewhat protect the rights of Afrikaans. But then equally, what the judgment that Justice Cameron tried to illustrate through his judgment, Justice Cameron, is that we need to perform a balancing act. And so as much as certain institutions have presented Afrikaans as somewhat a language of medium, or as a real-time language that they can get lectures or be lectured in, that if we are to do that and apply Section 29, subsection 2 to the letter, and for the purpose of that particular provision as was provided, as is attempted to be provided for in the Armello case, then we need to do so by doing it for all indigenous languages and not specifically for Afrikaans alone in unilaterally, which is what it would seem that was the attempt of the applicants, or at least that's the perception that is created, that now we had Afrikaans speaking students who were insisting that because of what was already previously done or historically done in that university, for them to be taught in real time, to get the material in their home language, that it would improve their studies. But same time, it's polarizing because of one, of the history that comes with the Afrikaans language, and two, because of where's the fair opportunity being presented, for example, at the University of Stellenbosch for isiXhosa speakers. I know it is quite a development that other universities are attempting to develop in terms of bringing in indigenous languages. For example, I know with the University of KwaZulu-Natal, in which they are attempting to introduce isiZulu as a medium for isiZulu speaking students at the university, because of in that part of the country there's a large number of isiZulu speaking students. And so this speaks to some of the issues that are discussed in the healthcare cancer case, that we need to do a balancing act, whether it's at any tertiary institution, high school or primary school, when it comes to the language policy in relation to Section 29, subsection 2. We need to if we're going to protect, like what was adamantly requested by the applicants in this Galke Kanse case, to protect the rights of Afrikaans as a language of teaching and learning, then the same needs to be done for isiXhosa, isiZulu, Tswana, Pedi, and all the other indigenous languages that we have in the country. But in the same breath, we need to do so within what's feasible and practical to do so. As in order to do that, we need to, there is financial implications in all of these things, and we need to, and universities do need to look at what is the demand in relation to those type of things, and that's what the University of Stellenbosch was attempting to develop in the form of a language policy in 2016. But yeah, it was quite an interesting discussion. But you know, obviously, it presents the question that how prevalent is the language of Afrikaans as a form of teaching and learning in terms of Section 29, subsection 2, as in terms of the right to education. Does it still bear relevance, since in 1976 that's what students were fighting for perhaps not to be imposed on students? But I suppose through judgments like this, as well as the Ermelo case, there is somewhat some light in terms of some strides being taken in a positive note and in a way forward through our courts. So yeah, that's my presentation from my side.
Thank you very much for that address, Advocate Chu. Also, thank you very much for sharing with us the Aramelo case. I think it's quite interesting to see that there's other aspects that we can sort of assess when we're looking at actualizing Section 29 for ourselves. And I think another aspect I'm equally grateful for is the fact that you have also shared a sobering view for me in that case in relation to the balancing act that the courts are faced with when they are adjudicating such matters. I think we need to have a balanced view when we're dealing with such matters, because they can be very emotive if you're looking at them from one side. So thank you very much for that address. We're indebted to you. Sorry for that.
You're very much welcome. Very much welcome.
Thank you. The next speaker that we then have on our list is Advocate Zimasa Mashia. Over to you, Advocate.
Hi, colleagues. How are you? Am I audible? Are you guys able to hear me?
Yes, you're audible.
Yes, you are audible.
Okay.
Okay,
Good morning.
thank you. Morning. President, I want to say all protocol observed, sorry. President, Deputy President, the entire executive of South African Black Women in Law. When we started, there was a quote that said, Igama lamakhosikazi malibongwe. I want to say that again, Igama lamakhosikazi malibongwe. And morning to the gentlemen who have joined us today for this special event. Such a privilege for me to be asked to speak at such a huge platform. I think it's such a big thing that we are discussing, issues of this nature. My name is Zimasa Mashia. I'm an advocate in the Eastern Cape. I think after the first address, I've sort of wanted to shift my address slightly different because I don't want us to take the same form. Sort of like reiterate the same thing. So my discussion then would be when we are looking at this right that is entrenched in the Constitution that all of us in South Africa are supposed to be entitled to, I want us to look at it and ask ourselves, where are we now? Where do we want to see ourselves in terms of this right being actualized? And what can we do to get there? First and foremost, you would understand, based on the Constitution, it is a right that is afforded to every child or every citizen in South Africa. It says we have a right to education, and not just education, but good education at that. Currently, when we are looking at things, this right is not really a right at the moment. If we're looking at it properly, it's still a privilege. Because I want us to look at it on a primary level. Do all children in South Africa have access to education? Before we get to the question of good education and education in our languages and our official languages, the accessibility, how can we access, are we able to access education? And the reality is that a lot of children in South Africa don't have access to that right. We don't have access to education. Before we go to the secondary level of saying, should we be taught at a varsity level, should we be taught in our languages? Is it possible? Can universities cater to us when it comes to that? What can we do to make sure that that right is being actualized? One of the things, rights, human rights it's not a standalone right. This right is not a standalone right. There are other intervening rights that need to be realized before we get this access to education. You will see at a primary level, children are not able to go to schools because they don't have access to proper health care. They are not able to have pads. But at a time, sometimes a girl child will not be able to come to school for certain periods out of a month because they don't have access to basic necessities such as pads. By the time you get to university, you've sort of like gotten over the first hurdle. Some people don't even get to the level of getting to matric to even qualify to get into a university. That is why I said it is a privilege at this point. You then get to university level, you apply, you get accepted, you don't get accepted, but then you look at the issue of funding. You're not able to pay the registration that is required. So it's another hurdle for you to get into a university. So by the time you are at university level, you've had to fight so many battles to get to that. You get to a University of Stellenbosch. Good marks, you maybe got funding, you got a bursary, you are at this university now. And you realize that the language, I'm not able to understand fully. Because when we look at our background, there's a lot of children who come from villages where English, as much as we might think everyone knows English, but not everyone is fluent enough in that language. Now you add Afrikaans into the mix, a language you've never heard before. Well, you've heard it, but you've never spoken. You're a young lady from Kukumbu. Everyone in your town speaks in isiXhosa. English is taught at school or was taught in school. And even at that, some languages were taught in isiXhosa. For instance, you get taught English in isiXhosa. That is a reality that is faced by a black child in South Africa. Sorry about that. So you get to university now, there's this right that you want to be taught in a language that you understand. I am for that right. Maybe when this judgment came out, I think there was a debate at my chambers about is it fair for these white people to say we want to be taught in our language in Afrikaans? And my view was it is fair. It is fair in this regard. I understand our history with apartheid, and when it comes to Afrikaans, it's a touchy subject for a black child. But don't look at Stellenbosch, look at University of Fort Hare, look at Walter Sisulu in Eastern Cape. Majority of those students are isiXhosa speakers. Would it be a touchy subject if a student from Fort Hare or from Walter Sisulu said, I want to be taught in isiXhosa? Is that an unfair thing? And then some of my colleagues were like, no, it's not unfair because we are Africans. Obviously, we get into politics about apartheid and the language. But in the main, those students who are saying we want to be taught in Afrikaans, they were justified. The right is there. South Africa caters for that. Our constitution says every child should have that right. And I believe every university, if the university is in Eastern Cape, predominantly in that province, there are Xhosa speakers. We should be able to have classes in English, and we should be able to have classes in isiXhosa. In Free State, we should be able to have classes in English, classes in Sesotho. I think that's what's predominantly spoken there. KZN, same thing. We should be able to have classes to, in isiZulu. Students must be taught in a language that they fully understand. The reason why, I don't want to be too political, the reason why a lot of white people, Afrikaners, thrive in their fields is that they get taught in their language from the onset. Primary level, high school level, and university level, they are able to get that, to be taught in that language. And the reason for that is because their ancestors or forefathers paved the way for that. So it's not only fair to say the Constitution says this government must pull through. We, as the people who are at the forefront, we are at this level now. We have graduated, we are lawyers now. It is up to us to make sure that we go back to our universities. We make sure, because we cannot rely and just say we're going to take matters through courts. But what are we doing, Tina, as legal practitioners? I'm just going to make an example and narrow it to us as lawyers. What are we doing? Are we going back to our universities? What are we doing? Because we want to get to a point whereby one day every child in South Africa is able to access good education in a language that they fully understand. And that is the duty that it's on our shoulders. Because when we look at the youth of 1976, they were being taught in this language until they decided, you know what, there's no one who's going to come outside to come and save us. We need to save ourselves. We need to, get up. We need to fight for what we think we are entitled to. And unfortunately, even though we are in a democratic South Africa, we still need to fight like that. It's just we are in a democratic country. We do have this Bill of Rights that says you have this right. But in reality, do we really have it? We don't. That means we need to have another uprising, maybe not as violent as it was in 1976 because the circumstances have changed, but we need to have our own uprising now as a legal practitioner of this time to make sure that we're making sure that universities are able to cater to the Black child, the Black girl child, who we need to make sure that is able to get to university, be taught in a language that they understand, and then get into the field and practice so that generations to come don't face problems such as these ones. Because 1976, they had the same problem. We still have that problem today. Even though a lot of people do have access to university, we still have that problem whereby there are lessons that are taught in a language that you don't understand. For instance, in Pretoria, I've got a friend who studied in Pretoria. I think she studied medicine around 2004. Classes were conducted in Afrikaans strictly. Even though she was there as a Black girl, she was a Zimbabwe national. She couldn't understand a word because in Zimbabwe, Afrikaans is not spoken. They speak Shona and they speak Ndebele and they speak English. She gets to South Africa, she gets enrolled to this program, and Afrikaans is being spoken. The lecturers are in Afrikaans. Most of the students are in Afrikaans. She stayed here because she wants this education from this university. But was that fair on her? It wasn't fair because that was 2003 or 4. Already by that time, we had this constitution that was sort of promising her this right, that you do have a right to be taught, maybe not in Shona, but at least English, because that right says you have a right to be taught in an official language. When we look at South Africa's official languages, we've got 11. So it means we need to find ways whereby all the universities in South Africa are able to cater for those. Are we able to get that at this very moment? No. Do we have the resources at this present moment? No. Government is not going to do that for us. How then do we get there? I have started wanting to have sessions with university students whereby we go and have talks with them. If you have a lecture in civil procedure, you go and have a discussion in isiXhosa. because I find it sometimes for you to understand a concept, it needs to be explained in your own language, and then you are able to understand it fully. How I always make this example, how I do things in my practice. I will read a case, I'll look at the facts, and I'll sit down and I would be like, okay, Zim, explain this in isiXhosa. Will I be able to explain this to Umama from Kutsolo, who is 50 years old? Let's start there. What are the issues? Can I explain it to a Xhosa speaking person without using these legal jargons? If I'm not able to, then I don't fully understand the concept. I don't even understand the issues that I'm faced with, because if I'm not able to explain it to a lay person in their language, then there's a problem there. And once I'm able to fully understand whatever legal issue I have, then I'm able to deal with the problem and converse in English and look for my cases, draft, and do all these things and know how to draft, because now I fully understand. And I think that's the problem we face in South Africa, even with those who have access to universities. There are concepts that they've never really understood, because these concepts were taught in a language, in English, even though that's the medium of instruction, that's the language that is widely spoken, but not everyone really understands English, fully. So I think those are the things that we, as well as the youth of South Africa, need to do. We need to go to primary schools. We need to go to high schools. We need to go to universities. We need to preach the importance of language. I've also started collaborating with a colleague who's a dean at the University of Western Cape. He's dealing with linguistic things, dealing with the language. They are wanting to go to, they have started to go to courts in the Eastern Cape to ask, why are proceedings not conducted in isiXhosa? Classic examples, there was a lady in a court in Kuqumbu who was raped, and they get to court, matter goes to court. The magistrate is Xhosa, the prosecutor is Xhosa speaking, the lawyers, everyone here is Xhosa speaking. But for some reason, the proceedings are conducted in English. Along the way, her talking or giving her version, her testimony, the interpreter interprets it a different way. When you look at the transcript, you see a different version, but not the version that she testified in English. Now, when that matter goes to appeal, everyone in that room is a Xhosa speaker. The question was, why can't these proceedings be done in isiXhosa? Why should we speak English in a room full of Xhosa speaking people? Why is that? And what can we do as the language department from this university and come and collaborate with the legal field in trying to ensure that if you want to make sure that there's proper access to justice for people, we need to be able to speak in a language that they understand. So a whole lot of people will know that there's a right to education, but they don't really understand because it's not being spoken in a language that they understand. I have a right to legal representation. I have a right to, have my case heard in court, but they don't fully understand it because it's not being spoken in a language that they understand. And a lot of times you feel that justice is then denied because there's this language barrier that we have. So we need to get to a point, and I love these discussions because they make you think, but I think we also need to move from that level of discussions and then we say, what can we do? How do we implement? How do we, get to a point where we are in a South Africa where everyone is able to be taught in a language that they fully understand? When will this right ever be actualized? Because it's one thing to have it on a constitution, but will we ever get to that? I understand the cases of Judge Cameron and the concerns that they raised. Obviously, does Stellenbosch have that capacity? I think at some point, one of the council, their argument was that we're going to need about 640 million to make sure that we are able to cater to both English and Afrikaans. That's a lot of money. Do we have that? No, we don't. Will the government ever give us that? No, probably not. And that's just only Stellenbosch. Because Western Cape, maybe Western Cape will be like, no, there are Xhosa speaking people here. We want classes to be conducted in isiXhosa. And you'll find that University of Cape Town, there are classes in English, isiXhosa, and Afrikaans, because predominantly those are the languages that are being spoken in Western Cape. Joburg would be tough there, because I mean, there's so many languages there. There are Venda-speaking people, the Tswana, Shangaan, and so do we have the budget for that? No, we don't. That's why I'm saying we need to look at the primary route, get to it at the primary level. Look at ways and find ways in which we make education a basic human right that is actualized and not a luxury, because at this point, it is a luxury. I understand NSFAS, but not everyone gets NSFAS to get into a university. So it's a bit of a tough topic that we are discussing today. But looking at it, have we moved really from 1976? We're still facing the same problems. They did their bit. Fine, they were then able to be taught in their language, but that was at the location level. Soweto. Everyone in Soweto was speaking their indigenous languages. There are no white people there, so no one had issues with that. Okay, fine, get this right that you are wanting. But at a university level, how do we then get to a point whereby we achieve that? I think there's a quote I was reading here by Nelson Mandela. I can't find it. But he was saying, it is not beyond our power to create a world in which all children have access to good education. And maybe to throw it there to everyone, what do we do? How do we make sure that these rights, or this specific right to education, is actualized? What can I do, Mna as uZimasa, to make sure that that right is actualized? What can we do, Tina, as South African Black women in law? What should we do? What can we do? What can I do as advocate Koketso from where you are? What can I do to make sure that this right is being actualized? So I think maybe the thinking should be around that. It's a tough concept. It's a very touchy subject. Very touchy and very emotional, because the language that was being debated was Afrikaans, and we've got issues when it comes to Afrikaans because of our past. But let's not look at it as Afrikaans. Let's look at it as, what if it was a student fighting to be taught in Setswana? Would our views be different now? I don't know. Program director, I think I've spoken over my time. I still want to go on and on and on, but I don't want to detain everyone here. I think that's where I should end. But the long and short of this address is that currently the right to education is still a privilege. Not everyone is able to access it, let alone a right to education, you being taught in a language that you in an official language of your choice. That's a secondary step. We haven't even achieved the primary one. That's a secondary step. What can we do? Where to from now? What can we do as the young people of South Africa? Before we go through the courts, take matters to court, before we get to that, what can we do at the root? Or we need to go to the root of the problem. What can we do? Because this is a problem we are now facing at a tertiary level. But the problem is from the bottom, from the primary level. Proper access to education at the primary level, at high school level. By the time you get to tertiary, you've fought so many battles. So I think that would be my address. And thank you. Hi, is anyone? I think everyone's muted. Guys, where are you?
No, we're not muted. We're still here.
No,
we're listening to you.
So I see I was muted there for a moment.
Oh, what? I'm like, okay, I'm talking now. Am I still connected? What is this?
I was just saying that thank you very much, Advocate. What you provided us was a solutions-based approach in terms of the idea of where we can start. More especially in order to ensure that the next generation does not face the same issues that we faced. Because if they do, that would mean that we would have failed in fulfilling our generational mission. So thank you very much for that. We were very grateful for that address. Questions from our audience. If there's anyone that has a question that they need to, or rather they want to pose to the two speakers that we had, now would be the time to raise your hand and let's proceed with that. I see former president has already taken that and raised the hand up. I think we can start with you, former president.
Good morning to everyone. Good morning to our panelists. As already been introduced, my name is Khululiwe Keswa, former president of SABWiL. So I have a question with regard to the Bella bill, and I think as some of you or all may know that there is proposed amendments to the Basic Education Act. So Advocate Zamasa mentioned something about starting at the bottom. So one of the things that I mentioned that are going to be amended in the Bella bill was that a school can have more than one teaching language where it is possible. And I think Advocate Choe, if I'm pronouncing your surname correctly, Gogezo, also mentioned that portion of Section 29 in the Constitution. My question then would be if anyone has read the Bella bill and seen the amendments on the language part, where a policy will now have to be created or incorporated in a school's policy to try and incorporate other languages. For instance, in Alberton, where I stay, there's 2 Afrikaans schools, and just in the area, there's 2 Afrikaans schools and 1 English school. One English primary and 1 English high school. Now, in your view of the amendments, do you think as a country we are ready and prepared and have the budget for it where amendments such as these are concerned? Advocate Zamasa, you mentioned that the right at this instance is not really a right, it's a privilege. We already cannot afford to take all our kids to school. Is the Bella bill rushed? What's your opinion?
My opinion on that, it's not rushed, purely because one, we are ready, number one. The only problem that we face, do we have the budget? I think that's where our main problem is. Even if we would have the budget with the knowledge of how our government is, will the budget get to where it's supposed to get? Fully, will it do exactly what it needs to do? Because I don't think we are a poor country. I think we do have the money, but I think our biggest problem is corruption. Like I said, I don't want to get into politics much, but I think this, like I said, this is not a standalone right. There are other intervening things. Corruption, like what we are saying, corruption. You want to actualize this bill. You want to ensure that, schools, all children at that school are being catered for. You're going to have to build classes. You're going to have to appoint teachers. You're going to have to do all these things. We might have that budget, but will that budget be fully utilized for that? Otherwise, tonight, us as a country, we are ready. We are ready, but when it comes to finances and the budget, that's another problem. It needs us to attack the issue of corruption, So yes, the long and short of it, yes, we are ready. Budget, I don't know.
Perhaps then that would be the start for communities, in my view, just to add on what you're saying. Part of that amendment speaks to parents preventing kids from going to school. Now, there's been many cases where you find that a child doesn't go to school because they say girls shouldn't be more educated than boys. Now, it's a culture issue. Now, this bill criminalizes preventing your child from going to school. your take is that we are ready. In your view, how is the government going to monitor all of these? Because there are many children who, at this point, as we speak, all races, don't go to school. I know one family, and I think I was talking to Deputy President about that family. I assist the family every year. The woman has got 9 kids, and only 4 of those kids go to school. How, in your view, is the government going to regulate this, ensure that those kids get to school? How do we, as SABWiL, as an organization, and people like yourself who are taking part in growing communities, what do you think would be our contribution in assisting to get the Bella Bill moving along, apart from the budget and the corruption and all of things? In your view, how can we then draw in communities to assist the government to run the Bella Bill and make sure that every child accesses this privilege of education?
Like I said, you know, okay, I don't know where to start. I think I've got an overload of thoughts in my mind right now. You said, I think if I heard you correctly, at some point you said there were parents who don't allow their children to go to school. My take on that, get them arrested. Listen, report them. I think we need to go back to that culture of whereby, I know times have changed, but there was a point back in the day whereby my neighbor's child is my child. If you're seeing something wrong next door, you're not just going to keep quiet and fold hands. If you're seeing that there's children or parents who are not allowing their children to go to school based on whatever reasons, religion and whatnot, you are able to report that. Let's be that type of a community where we're not going to sit back and say, it's not my child, it's the neighbors. And 2, before I came into practice, I had an organization that, like President said, we were focusing mainly on women and children. I've got a passion for that. But what we were doing, it was not specifically directly dealing with education, but we were dealing with domestic abuse, gender-based violence. So I still am part of that organization, but I resigned as a director. I'm not fully active. But what we would do is in our neighborhood, we had what we called was a white door. So if someone gets raped or whatnot during the night, we take them in. It's a home of safety. Our duty then is to the following day, help them go to report the matter at the police, or if it's a child who's in an abusive environment, we take that child on a Monday, or the following day we have to take them to the social workers. That is what our duty was. And initially people had problems with the organization because we are now meddling in issues that do not involve us. But if the community is silent, if we're quiet because we are not directly affected, I seem to think we're also part of the problem. So I think us, as well as onlookers, we need to do something. We need to make noise. We need to go and knock and say, listen, social development. There are kids who are not able to have food. They don't have clothes. And we knock at doors to say, there are parents who don't want their children to go to school because they are girl children. Get police involved. It's going to take a lot, but if we all come together and have a common goal, it won't be as big of a task because everyone will be in it. But I just don't know how we would get to a point whereby everyone has the same mindset that if you are seeing a child not going to school, what can I do? Do something about it. Let's not take that approach. It's none of my business. I think definitely we are ready. We will never not be ready. I want to stress that we are ready, but we as the people, we cannot, unfortunately, rely on government. Government is not going to do anything for us, unfortunately, if we don't do anything. I think it's us now. We need to, take up arms, not literal arms, but I think we need to take up arms and try and fight. Sit down, strategize, focus on an area. Okay, we're focusing on girl children who are not allowed to go to school. Where can we report this? Sure, I understand it's your house, it's your children, it's your rules, but that child unfortunately does have a right to get access to school. get access to education. What can we do as an organization? Then you focus on one area. Another organization will focus on another area. Another will focus on another area. We're not all going to do it at the same time and do everything, but we just need to zoom into one area and see, identify, this is the problem, and this is the problem as South African Black women in the law. This is a problem that we are going to tackle, and we're going to tackle it this way. Then another organization, SABWiL, will say, this is what we are doing. Because I know as a member of SABWiL, what we do a lot, we usually have school drives, whereby we buy school uniforms to children so that we make sure that there's no child who's staying at home to say, no, I don't have shoes. We try that as an organization. It's one of the things we do every year, almost, well, not even once a year, more than once a year. Whenever we can, we're always collecting shoes. We're always going to these schools to encourage these children. You are able to come to school, but you don't have shoes. Therefore, you're going to stay home and not go to school because you don't have shoes. So we try to do, each and every organization must identify a goal and work towards that.
Thank you so much. That answers all my questions. Thanks.
Thank you very much for that wonderful discussion. I think, yeah, the two questions are really the two questions and the answers to the questions are really quite insightful. I see that we have a question from the Deputy President. You can go ahead.
Thank you, Program Director. This question is directed to both speakers. Advocate Zimasa, you asked, is it fair to want to be taught in a language of choice? And my response to that is, oh, actually you said, is it unfair? And my answer to that is no, it's not unfair. However, I have a few questions. And the first one is it reasonably practicable? Because in South Africa, we have 11 official languages. So I know that you said we are ready, but how exactly are we going to teach in all 11 official languages? And also, is it progressive? If for some of non-English speaking people or students, it takes longer for you to translate your thoughts into your words. So now if you are taught from grade 1 in Zulu and you get to varsity where there's diversity, you find Afrikaans speaking people, you find English speaking people, and now you have to start from scratch to adapt to this universal language of teaching, which is English. Don't you think it's going to take you longer to understand the syllabus? And also, how much power? You also mentioned that it is in our hands. We need to be the change that we want to see. But how much power do we really have as the citizens of South Africa in effecting the change that we want to see? The former president just mentioned the Bella Act, which seems to give more power to the head of department when it comes to admission of students in basic education. How much power do we have then as people?
Okay, I'll let Koketso answer after me, but I will try and answer you here. It's precisely my point. You get a child that is being taught in isiZulu all her life. She gets to university. All of a sudden, she gets taught in a language she doesn't understand. How I say then we need to come in. We need to come in. Like I said, I do sometimes go to universities to go and have these talks and try to explain a course in isiXhosa, because I'm obviously from the Eastern Cape. Those are things that I just do myself to just contribute to my country and the future I want to see. Probably in Eastern Cape, with the university I go to is Forte, because I'm an alumni there. There are Xhosa lecturers. So they would also, it's something that we would also encourage, listen, try and explain it in isiXhosa. I understand there are English speakers and Afrikaans speakers, but sometimes apologies, sorry, I got cut. I'm connecting via my phone. With the issue of the head of departments, that is when we will have to come in legally as the lawyers to say, there is this act that says you need to admit these children, and you are not doing that. Then we look at the availability. Is it reasonable? We look at the reasonableness. Is it reasonable for the head of department? If it is, then it definitely needs to be. It definitely needs to be done. We need to admit these children, and there needs to be a language policy. They need to have access to education in a language that they are able to understand, if there is a possibility. But also, as the head of department, what are you doing to try and ensure? Because we do have assistant teachers that get employed in a way to come and assist. Why can't you utilize those to say that if we are in Gombo, obviously I'll make example of the Eastern Cape, sorry, and we need assistant teachers, I'm going to get an assistant teacher that is Xhosa speaking, because this is a predominantly Xhosa school, especially in the villages. Strictly, probably everyone there in the class is Xhosa. Why can't we get an assistant that is Xhosa? If we go to an area whereby there are colored areas, if I can put it like that, not sure if I'm politically correct, there would be Xhosa speaking and colored children. Why can't we get assistance if the teacher is Afrikaans speaking, a colored person? Why can't we get an assistant that is in Xhosa so that the class is balanced? Because the department does cater for those. It's not just the teacher, but there are also student assistants, these teacher assistants, I don't know what we call them, but these young people that get roped into schools to say, come and assist. There's just ways into trying to figure these things out. So once that is done, we go to the head of department to say, listen, what are you doing? Because it's not going to be fair to say, well, I don't have the capacity, there's nothing we can do. But what are you doing to make sure that that right is being actualized? I don't know if I'm answering you properly. I'm trying to.
Yes, you are. Thank you. Over to you, Advocate Koketo.
Thank you. I think my learned sister, Advocate Semesa, gave, I hope I'm pronouncing your surname correctly. Okay, thank you. Yeah, I think she did clarify the issue quite well in relation to it. I must commend her presentation. It was actually quite well structured in terms of, we do need to take this issue to a grassroots level in terms of implementing section 29, in terms of the right to education. It's obviously the Khalkia cancer case, I hope I'm pronouncing it correctly. It spoke to a policy being developed in relation to that, to speak to trying to balance out these rights, these constitutional rights. Now, this Bella Act, the amendment in terms of the Basic Education Act, I've not read the bill as yet, but I'll sure to give it a read. But from what I gather, or what I'm hearing, is that it's an attempt by the government to implement and enforce the rights in Section 29 on a basic level. Perhaps, and I echo the same sentiments as my learned sister, that we are ready from a legal standpoint to enforce it. It's just the issue of obviously financial constraints, whether it be corruption, whether it be how do we budget it, how do we financially structure it. You know, in terms of it coming to the fore, how do we safeguard corruption not occurring and looting not occurring when that budget or structure is put in place. Those are other separate discussions, but of course these are discussions that must be had. But as my learned sisters echoed, we do need to take this issue on a basic level and try to implement it. Perhaps from a demand aspect, in terms of some areas predominantly having, whether it's Afrikaans or isiXhosa or Swati or isiZulu speaking children, we do need to have it. And I suppose we do need to also look at in terms of how is our basic Department of Education implementing the enforcing the right of education, because of ultimately it is their job to ensure that this right is enjoyed not just by those who are privileged, but by all South African citizens. And so we do need to look at how this is enforced. We already, it's perhaps also a lack of, how should I put this? Also a lack of political will in terms of we as South African citizens, we need to be actively assisting in that regard. I mean, you know, as lawyers, we will assist in terms of, we can assist in terms of policy drafting, enforcing the rights in court and so forth. But I think also as South African citizens, just from a basic level, we do need to, you know, look at how do we get involved in ensuring that these rights are enforced, because of, I mean, it's horrific, to be honest, hearing that some girl child somewhere is being told she can't study because of she's a female. That's completely ridiculous, and it's horrific to hear that, because of we're not in the archaic old age era, so to speak, in terms of limiting children's rights. You don't know that the child that you are somewhat imposing such archaic views on could be the next president of the country, could be a minister somewhere, could be a lawyer tomorrow. You know, you don't know, and so it's archaic, and so we do need to do something in terms of ensuring that such things don't happen. But to speak to in terms of the language aspect, I think it needs to firstly come from a demand aspect in terms of different parts of the country. We already know off the top of our head, in certain parts of the country, for example, in Eastern Cape, where isiXhosa is predominant, you know, then what is the university doing to ensure that we can enforce it? The bill is there, for example, like this bill that's being presented or has been presented. But how are we then now looking at and saying that are we going and assessing, okay, for example, in this particular part of the country, we have predominantly this particular language. How are we now including it into the system and implementing the policy? So, I mean, even when we look at the Kanzea case, this was the university actually, even if one might argue in a bit of a timid way, but attempting to enforce a situation where there's space to be flexible for the university to teach not just in English or in Afrikaans, but also in other languages. But it's a matter perhaps of how do we implement it? What system can we put in place for that to be implemented? Sorry, my laptop is just giving me a warning. So just give me a second. Sorry about that. Yes. Yeah, my battery was just dying there to put the charge on quickly. But we do need to look at how do we implement it, you know. But it does require political will from us as South African citizens. It does require us as normal South Africans who are able to assist in this regard to actively participate in ensuring that these rights are being protected, are not being infringed, are in play, and not just for the privileged. So yeah, but I can't say too much because of my learner sister said a lot of the things I could have said. But yeah, we do just need to ensure that these rights are protected, because of it is there in the Constitution. We are ready. It's a matter of political will, essentially. That is what is important.
Okay. Thank you, Advocate Kogetso. I think I have one last question. I see Peter's hand has been up for quite some time. Sorry, Peter, I'll just ask this question. Maybe we can save it for later. Bring it back now to the legal practice. Are we facing any challenges or issues when it comes to actualizing Section 29? And if so, what issues are those? But like I said, we can just park it for later because I see other people have questions.
Okay, I think, yeah, let's park it for later, because I also have a question in relation to section 29 and the legal profession. Let's go to Advocate Peter's question.
Mine is not so much of a question, but rather a comment on what all three speakers have put forward. First and foremost, in respect of readiness, there's no question about it. We've always been ready, and one does not have to reinvent the wheel, because as far back as 30, 40, even 50 years ago, you had a state of affairs wherein students from elementary school up to middle school would be taught in the indigenous languages that were found in amongst all indigenous South African folk. And then it would then be toned down a bit when it came to high school and secondary school education, wherein English would be given prominence, because one accepted that from a methodology in education point of view, you've got to prepare your students for university and all other tertiary institutions. And even in doing things that way, we were able to produce Black A students at South African and global universities. So from a methodology point of view and a readiness perspective, we are ready, and we've never been readier than we could ever be. And then, of course, when Zimasa spoke, right, what came out for me, what stood out for me was that it's not just a matter of the corruption, because even if you remove the corruption, without the political will to get the job done, you're not going to get out of the starting blocks. So the political will has to be sufficiently strong for the communities to actually, and the education department to actually get the job done and ensure that even the corruption does not come into the picture. So I'm happy Koketso identified it, correctly there. And then, of course, Zimasa also spoke about where you find some of these problems, get the parents arrested. I would take a different approach there, and I'll explain why. I function from, and I discovered this when I did research amongst the Bushman communities in the Northern Cape, the San, with the San communities, and they have a methodology known as therapeutic and restorative justice. And what I find there is that if you have those parents arrested, those children come back to a home without parents. So we as members of the communities need to go back to the old ways of doing things, because there was a great deal of wisdom in something as classic as Ubuntu, because we have these conversations, we see something go wrong in the community, we call the elders, even some of the youngsters, so that we start the process of handing over the baton to future generations. And we have a sit down with the mommy and daddy in that household to say, listen, this is a problem. And if we as a community, as a village, are to build in the way that we are supposed to build, we will help in getting this child to school. Why do you not want the child to go to school? They tell us their problems and we intervene. So it's those community interventions that help. And then the children get to go to school. When that child go to school, and there's a transport issue in the way that it used to happen when I was growing up. My granddad's car would not only fetch me from school, but it would also fetch a lot of my friends, and we would drop them in different parts of the township. That's how we ensure that we get children to school. And we also help the parents overcome the insecurities without embarrassing them. in the process, because you put that parent through the criminal justice system, they get locked up, and ENCA will be happy to splash it all over the news. Daily Maverick will be happy to splash it all over its pages for the sake of selling magazines and all that and subscriptions. But we shall not have dealt with the problems. And the aim is for us to deal with the problem in a restorative and a therapeutic manner, so that we build a healthy community with well-adjusted, not maladjusted future leaders, you know. So I'm appreciative of what everyone has said thus far, but those are things that I think we've got to look at, and the conversation on methodology needs to be had. We need to have that conversation and get people to understand that when we switch it over to English and maybe a language such as Mandarin, given where the world is going, we are not disrespecting the indigenous language, because we will have done the work from elementary school level up to high school, and as a consequence thereof, you have a balanced human dignity approach towards the languages of indigenous people, because June 16 happened because the Nats wanted to do away with all other languages and shove Afrikaans down people's throats. If you do that, goodness, if I'm a Boer and I'm told that I'm going to learn in isiXhosa only, my gosh, I would also revolt as hard as the blacks revolted. You know? So we've got to understand the historical balances and sensitivities that play into the whole discourse, and not allow the whole indigenous language right to be hijacked by the politicians, because as Zimasha has said, you're not going to get much out of the politicians, because it is not executively and administratively convenient for them from an election point of view to do the work for you. And I also want to put this on the table. The power does not lie with the politicians. It lies with us, the people. And we've got to recognize that. And Makeswa, the other thing I would like to talk to you about is those children who are not getting to school. Let us get to I need to get to the bottom of it and see how best I can help, so that we remedy this very unfortunate state of affairs. That is my part for now. I'll park it there. Oh, sorry, before I go off. With regard to the Act, or the amendment of the Act, right? Again, these rights, these pieces of legislation must be read in conjunction with the African Charter, which deal with the Republic's international law obligations in as far as the rights of the child are concerned. And there's a protocol that deals with the rights of children. So we've got to ensure that that amendment aligns with that, because already sections 28 and 29 of the Constitution already align with that. And then you've also got to factor the Hague Protocol on the rights of the child to ensure that these things are properly aligned, because if it is done in a rather choppy and disjointed manner, the risk always remains that these things will not align. And then lastly, with regard to the right to education and the right to being educated, not really translating into a right, but rather a privilege, I'm going to adopt a different approach and say, the fact that the authorities are treating it as a privilege instead of a right does not do away or negate the fact that it remains a right. And we have an obligation to insist that this inalienable and inviolable right gets to be exercised, asserted, and protected, because people paid with their lives for us to have this. World War II happened and the UN Charter was born, and not just that, the Universal Declaration was born, and these things come from there. So we've got to make sure that these things are given effect to. So that's why I'll park it for now.
Sorry, if I can just quickly come in there. Thank you so much, Peter. I think I needed that. I think the radicalism in me was like, arrest those parents, arrest those parents. So I truly do appreciate wisdom, you know, of an older person, really, to say, listen, maybe this might not be the approach, but let's speak to these parents and let's, you know, let's have therapeutic or ways, interventions we can get in there with, and not just arrest them. That is the radical in me saying that, listen, arrest them, they must be jailed. But definitely it is not the approach. So I am in agreement with you. Thank you for that, Peter. It really helps to have some wisdom.
One has to be mindful of that, because let me tell you, these problems are frustrating to all of us, and in resolving them, we've got to ensure that we do not allow our frustrations to get the better of us, because at the end of the day, this guy, it could have been me. The shoe could have been on the other foot. So we've got to find a way of winning minds, and not just winning minds, but the act of winning minds is the easier one. The more difficult one is the act of winning hearts. Because with a mind, you convince, but with a heart, you've got to persuade, you know. And we've got to all remember that we, from an Ubuntu perspective, used to speak in a healing voice. And we must not lose sight of that. That's how we survived 1976. That is how we survived 1985. That is how we survived 1987. That is how we survived 1989, to the point where 1989 forced the white man to recognize the fact that we've tear gassed them, we've shot them, we've hand grenaded them, we've dynamited them. They still remain. And they had to get rid of the old crocodile and go on to a referendum to give us what we wanted. So this is part and parcel of what Nelson Mandela told us, you know. Phase 1 is over. Now phase 2 of a burgeoning democracy presents these problems. I don't see them as problems. I see them as challenges. And these are nothing that cannot be overcome. So, and we stand a better chance of overcoming these things if we look at our value system in this country. That's what makes this country so uniquely beautiful. Thank you.
Thank you very much for that engagement. I'm trying to find a plural for council, but it's escaping me, so I'll just say council. Yeah, I think
council in singular is council, and council in plural remains council. It's a collective noun. If I ever hear you say councils, please don't tell people that you know me.
I'll beat you up too.
Thank you very much for that, Advocate. But I was just trying to say to Advocate Zimasa that, you know, it's very easy to be radical when you're dealing with Section 29. It riles up emotions. I also see that our president has a hand up. President, over to you.
Thank you, Tsidiso. My question is more of the side of the legal practice, I guess. Under Section 29, subsection 2, there's a wording that says there, in order to ensure the effective access to and implementation of this right, the state must consider all reasonable educational activity alternatives, including the single medium institution, taking into account. Now, Advocate Zimasa and Advocate Kokezo, they both mentioned something. They raised the matter of having a budget. Now, if I may ask, if we're taking it back, in 1976, we are able to recognize that there was a language barrier. So right now, from what they had said, I see that there's a financial barrier. Now, with what LPC amended, the rule that LPC amended under Rule 22.1.11.1, it says that it is a misconduct on the part of an attorney seeking to employ a candidate legal practitioner to stipulate in an advertisement that it is a requirement that an applicant must be, or to inquire of an applicant whether he or she is in possession of a valid driver's license or owns or has access to use of vehicle for use in the course of his or her prospective employment as a candidate legal practitioner. Now, with what you have said with having a budget, now my question is that, seeing that there's a lot of disadvantaged students who are coming from this side, from the Eastern Cape, and also that there are many unemployed legal practitioners, and also there is a huge demand of unmet legal needs. Now, if I take it in this way, there is a supply and there is a demand, but the two, they are not lining up. My question is that, is it a matter of debt load that law graduates bear, which disqualifies them from a small, moderate and income practice? Or is that the law schools themselves, they are not teaching young legal practitioners how to navigate in this kind of practice, or the purpose or reward and necessity of that kind of practice?
Can I jump in there? You know, when you gave your background info in the run-up to the question, I thought you mentioned the issue of a language barrier in 1976. In 1976, there was no language barrier. The language barrier was imposed as Afrikaans. So initially, there was no language barrier to speak of, right? That's why 1976 happened. So let's get the historical context right. And then secondly, you pivoted over to the budget issue and linked it to your question, but then you dealt with the amendment at LPC level with regard to excluding candidates from being employed as candidate attorneys who did not have a driver's license. Again, that is a discrimination issue, you know, which flew in the face of Section 9, subsection 1 and subsection 2 of the Constitution. That is why that amendment had to come about. And then you talked about Section 29 of the Constitution with regard to the right to education, making provision for alternative, reasonable alternatives to be factored in the equation. And again, I'm battling to connect everything you've thrown at us, right, to your ultimate question. But let me deal with what the contents of Section 29 as in the way that you dealt with them. The purpose of the legislation being framed that way is to ensure that where in giving effect to this constitutional imperative, right, you have other means and ways of achieving the purpose of giving effect to this constitutional stipulation. Use them. You can use them. Don't leave them out and say, I'm only depending on Section 29. You've got other forms of methodology that enable you to get there quicker, you know. Use them, make use of them. Don't just camp out on Section 29. That's the purpose of the legislation. And then now you are talking about also, and then you pivot towards the end. You pivoted towards law schools, or rather universities, not preparing you guys to navigate what ultimately happens when you guys set up your practices. And it's not, you can't even blame it on the universities, and I'll explain why. A university is tailored to give you academic instruction, right? And with a university being tailored to do that, it does its job. And the university is also burdened with the fact that, and there's a complaint that I hear from a lot of academics, that the university inherits, problems like numeric illiteracy and functional illiteracy, which have not been dealt with in the schooling system, from elementary school up to grade 12. So the university's already overburdened them, but not that I'm making excuses for the university. But what it boils down to, if you ask me, is that there's still work that can be done. It's not a perfect system. One could introduce courses such as practice management, and even in the same way, we've managed to introduce trial advocacy at university level, but it still will not be enough. And that is why you guys have to go through an internship. Now, the problem with internships is this. At the bar, there is, you have practitioners who are looking at the practices. So the political will to invest money, to take from their own practices and invest money into a fund that would help interns who are fresh out of varsity is not of necessity there, because the private sector is a bit of a ruthless institution. It's not like the state, where a state institution where the state can reroute a budget and actually make it available there. That's problem number one. And then problem number two, these things, the saving grace, I guess, to problem number two, is that in as much as it is rough, your first 2 years are the toughest. Your first 2 to 3.5 years are the toughest, because now you don't have money after you've completed your articles as an attorney. You've now got to start building to set up your own firm, if you elect to set up your own firm and not work for someone else. And you basically start not from zero, but minus ground zero, because some of you start having with TEFSA or NEFSA's debt to pay off, one, and then others have and then there's also the issue of black tax, which all of us have to deal with. So, but the saving grace is that with time, the more work you get, the better it gets. And with the emergence of artificial intelligence and certain mutations in the internet, I've got a nephew who's a junior attorney, and there are apps that enable him to source work from all over the country. So for the attorney, it's easier to do that and to start building to start building a kitty of money. And of course, attorneys also have direct access to tendering for work with at institutions such as PRASA, SAA, and all that. And I've seen quite a number of young attorneys, fresh from varsity, having just completed their articles, land that big contract, and then before you know it, the firm is now growing. So all is not lost in as far as the attorneys are concerned. And then with us barristers now, the difference is that now, once you've completed your 18 months of pupillage, because I see it's no longer 12 months, it's 18 months, what happens is that you get to get work from your colleagues at the bar, and it's not always consistent, but it's enough to keep you going so that you can navigate the first 2 to 3 years. And those are the most difficult. But once you're past that, and then of course, the state, a lot of our Black colleagues get work from the state attorney. I am a bit different in the sense that I made a conscious decision not to do state work. Instead, I go against the state. So it's not many who do what I do. So I don't do state work. I shy away from state work, but a lot of Black colleagues have built their practices, and very, very lucrative practices with state work. And I get to do a lot of SOE work, which comes through private attorneys, which is nice. I love the private sector. I'm a believer in the private sector. So my practice resembles that of a Joburg Jew or a Cape Town Jew or that thing, a Cape or even a Joburg white man, even a Pretoria white guy. And you've got certain barriers that you've got to fight against when you set up your practice the way I have, because the whites feel that you're muscling in on that turf, and I just didn't care. I did it. And the other thing, the funny part, the other thing about me, and please don't get me wrong, I don't have an identity crisis. I speak Afrikaans as a first language. So I was able to easily muscle in on that turf. So those are I think in answering your question, I think those are, and I hope I've answered it as best as I can, and I've answered all aspects of your question, So all is not lost. You will succeed. Make no mistake about it. The environment is such that your initial 5 years are going to be your toughest, but hang in there. Please hang in there. And then, of course, now I might get into trouble for what I'm about to say, but I'm going to say it anyway, because once you're an as old a geezer as I am, you've got nothing to lose. To the young ladies here, right? And this is advice I got from the former Deputy Judge President of the Western Cape, Judge Jeanette Treveso. My advice is this, and a lot of young ladies are not told this because there's a certain level of fear that is sold to you, right? Ladies, men and women are different, right? As young ladies, get past the internship. If you want to get married, please get married young. Go and have your family whilst you are young and you do not have health risks. Do it before you get to 30. Raise that family and then come back to the bar, come back to the attorney's profession. Trust me, you will still do well and you will have your family intact. Don't wait until you're in your 30s, because if you wait until you're in your 30s, you risk a pregnancy that is going to be very painful. And I've seen a lot of my colleagues miscarry. It's painful. It leaves me traumatized. Forget about their trauma. I'm old enough to be a lot of people's dads who are at the bar, and I have to deal with children coming to my chambers in tears. That is painful. And if I can help you guys to avoid it, I would want to do that. All right. There's more to life than legal practice. Please, your mental health demands that you do it that way. Judge Jeanette Treveso said to me, "Oh, I actually went and had my family after pupillage and then raised my children until they were between 5 and 8. And that's when I came back to the bar, practiced, and then I got to take silk and I went to the bench. And you should see them now. They've got mouths bigger than what I taught them. They say horrible things to me." You guys should not be deprived of those experiences because your mental health depends on them. You need to get into a house and not find things where you left them when you left for work. You need to find that house looking like a hurricane blew through it after the children are done with it. I don't have kids of my own yet, but I have a 10-year-old niece who grounds me, and I'm raising her as my own kid. I fetch her from school. It's the best thing that's happened to me. 11 years ago, I used to be this tough lawyer with a steely reputation to protect. When that child came, I became a marshmallow, and I'll take being a marshmallow anytime. I'll park it there for now. You guys are going to do well.
Thank you, Peter. I want to also add on that what you've just said. I think most of the stuff I was going to answer to you've already covered. But obviously me, I'm a 32-year-old, been married for 12 years. I had my kids. And then I went to start to be a candidate.
Oh, you're talking.
In my late, no, I am quite old. So I did that.
No, you're
after
still
varsity.
young.
Well, depends. So after varsity, I was a stay-at-home.
I'm 50.
Don't fall for it, advocate. Don't. A woman never
I'm 50. I'm 50, and I'm not chasing after any lost days of my youth. I'm okay with being old. I love being where I am. It's a beautiful space.
Program director, I think we may have lost Advocate Ngazonke.
Yes, just to add on to what my learned senior said, Peter, Advocate Makambeni. Yes, well, I'll just stick to the questions that were asked. So in relation to the questions that were being asked, to the amendment of the LPC rules, I don't think they directly link with Section 29, subsection 2, and the issues that were amended in LPC. Perhaps to Section 29 as a whole, as vaguely so, as the issues in relation to candidate attorneys being told to have cars, being told to or have driving licenses, and being able to speak Afrikaans. I know that that is quite has been a norm for some years in Pretoria for a lot of law firms. I don't know, it's maybe because of the clientele they have, particularly in terms of Afrikaans aspect, or it's strictly to discriminate. But yes, these more relate in terms of section 9 in terms of the quality clause. So yeah, from that aspect, that's what it really relates to. But I think Advocate Makambeni, he covered a lot of these aspects. I must also thank him for the kind words that he said earlier about me. But yeah, look, in terms of from a legal practice standpoint, it is a discrimination problem. I believe the LPC is trying to forge a way to go around it and sort of deal with that particular aspect and issues, particularly when it comes to candidate attorneys, because of it's quite ridiculous. Because in a lot of instances, candidate attorneys don't have the money to have a driving license, let alone a car. In other instances, when it comes to Afrikaans, they don't even know one word of it, so it's quite ridiculous to have those strict particular requirements in the candidate attorney adverts. I can understand the Afrikaans language aspect to some degree, in terms of a law firm itself might have a lot of Afrikaans speaking clients, and perhaps that's why they would like an Afrikaans speaking candidate attorney. But still, it shouldn't be the case from a language standpoint, because of English at the end of the day is the medium that is widely used by many, and so it is quite troublesome because of that's why I'm saying the aspect of candidate attorney does vaguely connect to the right to education, because of candidate attorney or articles of clerkship are an educational experience. It is one being taught skills in that regard, and so it can't be that you're speaking you're being forced to be taught in a specific language other than English or your home language. So yeah, I'm not sure where everybody went, but yeah, that's just my bit on my side.
No, we're still around, Advocate. Thank you very much for those words and the words of encouragement, especially from Advocate Peter. I see that Nthabiseng has a hand up, but before I go to her, can I just ask the DP, because you, like me, had a similar question in relation to the LPC, and I've been answered in that regard. Have you been answered, or would you want to add anything to that?
I have been answered. Thank you, Program Director.
Okay, thank you very much. Let's go to Nthabiseng's question.
Hi, everyone. I hope everyone is well and can hear me. My apologies. I'm not in a position to come live on camera. And yeah, I just wanted to maybe more of a comment than question. Thank both the speakers and obviously now Advocate Peter, because when I read this case, it's always easier for me to understand things when I sort of try to center myself in it and try to understand, okay, Nthabiseng, have you actually valued language? Does it, or would it have ever made a difference for you, do you think, if you were taught in your own language? So, and I say this because for as long as I've been in school, I've only ever been taught in English as far as I can remember, and so for me, that was always normal. And now when I read this case, what came to mind was that what I appreciated about the judgment was that my issue with Afrikaans speakers, Afrikaans people, is that there isn't the ability to understand their privilege to have always been taught in their language and to therefore move in every space that they move in. As Advocate Zimata explained, they have the privilege to speak in their language, to engage one another in their language, and which most of us haven't had. But I was asking myself, and I think if I understood Advocate Zimata correctly, this is what she was talking to us about, is like, where's our own ownership? Because I've never really thought about, do I actually care as a Sotho-speaking person to need to be able to speak Sotho in different spaces? And I think it's only happened to me in adulthood, where I work at a small law firm, and once in a while you'll have someone call in, or when you go back go Soweto, my grandmother's home is in Soweto, and you'll have people who want you to explain particular legal aspects to them. And I found myself that, oh my goodness, I actually don't know. I know that explaining this in English is not going to get you to understand it fully. And so I was like, actually, I don't know how to explain this to you in your language. And that for me was, is it because Nthabiseng just hasn't valued how important it is for her to know her own language? And so I don't know if I'm making any sense. That's sort of where this whole conversation was taking me, about the power of your language and the identity it gives to you, and the way you're able to move and connect with people because you're able to speak to them in a particular language. And so, I mean, I know as a student, when I was in high school, in grade 8, I chose to study Zulu, but I was placed in an Afrikaans class because I was told that the Zulu class was too full. And now only am I able to think back and be like, actually, that felt it was so daunting, and I really, really didn't want to study Afrikaans. I only wanted to study Zulu because I just knew it, but I don't know that I actually valued it. I barely speak Zulu. I'm Sotho. I barely speak Sotho, so I don't know. I get where the Afrikaans students in Stellenbosch are coming from, because I just sometimes feel like they value their language more than some of, or let me not even say some of Black people too, because I'm not going to speak for Black people, but more than I have. And I think that's sort of what that's something that this brought up for me, that I just need to understand, have I valued the power of language and how it can make me a better legal practitioner? Yeah, that's all I wanted to say for now, I think.
Thank you very much for that contribution, Thabiseng. We're grateful for your contribution. I don't know, is there any other individual that still has a question? Have I missed anyone's hand? So I don't think there's anyone that still has a question. With that said, we can then move on to the next item on our agenda, because I see we're past the time we had said we're going to conclude. The next item on the agenda is the SG, who is going to just give us a brief summary of the event that we just that we just had. I think with that said, Madam President, can I then move to get the closing address? I've been informed that it's going to be rendered by former President Ms. Kuli.
Thank you so much, Program Director, for this insightful program, EXCO 2023-2024. This is really, really great. We appreciate the work and the effort that you have put into organizing this session. My address is going to be very, very short. And in the words of Maria Montessori, she said, education of even a small child does not aim at preparing him or her for school only, but for life. Section 29 enshrines in itself a right to education. This is not just a right, but a right that is recognized internationally as a human right. Our duty as society is to educate future generations and prepare them for the life they wish to lead. We need to teach them to think, not what to think. Our gender should not automatically discriminate us. This is a right that is legally recognized and guaranteed without any discrimination. It is our task as a society that when we leave here out of this session, we'll look within our society, look to our left, to our right, as we were taught when we were crossing the road when we were younger. You look to your left, you look to your right, and see if it's safe to do so. Check if there's anyone you are leaving behind who has had the opportunity to access this right. Help our communities to bring about the change that we wish to see. We are one with our community, and our community is one with us. Let us help build an educated nation, a nation that knows what comes next. Do join us as SABWiL in our annual stationery drive. This is our part as the South African Black women in law, where we try and ensure that all children have access to education, and when they do have that access to education, they have the tools to learn. Thank you today for joining us, and we pray that the spirit of the Ubuntu bug has also bitten you, and you may, as you leave today, participate in the changes that we hope to see as a society. Igama lamakhosikazi, malibongwe.
Igama lamakhosikazi, malibongwe. Thank you very much
you.
for the wonderful closing words, Madam President. We can now consider the session closed.
Malibongwe lamakhosikazi. Thank you so much, Exco, for this event. Goodbye.
Thank you all.
Malibongwe.
Thanks everyone.